Test 1, 2.
Good evening. Good evening, and welcome to Knox College's Constitution Day debate. My name is Andy McGadney. I'm delighted to serve as Knox College's 20th president. Last week, the college celebrated our opening convocation ceremony, and during my opening remarks, I reminded our community that Constitution Day commemorates the formation and signing of the U.S. Constitution in Philadelphia on September 17th, 1787. When the members of the planning committee gathered to discuss the venue for this evening's Constitution Day debate, consensus quickly gelled around hosting this event right here on the very site of the only remaining original building from the 1858 Lincoln-Douglas debates, Knox College's Old Main. We also chatted a bit about having our guest speakers to join the stage through the window to my right, but decided against adding that entree for this particular moment. The history records highlight that this event in 1858 hosted over 10,000 people that participated in the debate on campus, and our hope is that this evening, all members gathered here will find meaningful ways to engage in discussion, especially during our Q&A portion this evening. Since Knox's founding in 1837, our community has benefited from a healthy debate in the classroom, dining areas across campus, and within our Galesburg community. The opportunity for our higher education community to highlight the values of healthy debate is part of our mission to educate great minds to become global citizens. We must remember that debates are designed to allow opposing arguments to be shared with one another. It's an opportunity for thoughts to be heard, ideas to be tested, arguments to be sharpened, and in some cases to change your mind in support of an additional point of view. Debates are not battles where one side wins and others lose. This evening we have a special opportunity to participate in a public debate entitled, "Does the United States Need a New Constitution?" It is my hope that each and every one of you gathered here this evening will enjoy listening to our distinguished speakers, that you learn, that you grow, that you ask questions, and engage with one another in a productive way. It is now my pleasure to welcome and introduce our moderator for this evening, Professor Thomas Bell, Assistant Professor of Political Science and International Relations at Knox College. Thomas?
Thank you, President McGadney, and I just want to say welcome to all of you who've taken your time to come out to this, I think, exciting event that we have planned for you tonight. I'm especially excited to welcome you to the, as President McGadney said, the historic site of the 5th Lincoln-Douglas debate. And I think this is a really incredible place to have a conversation about the important question before us today. Regardless of the extent to which one is an ardent admirer of the Constitution or an outspoken critic, it's clear that our politics are dysfunctional today. And moreover, our governing institutions seem unable to meet the tasks of modern governance, especially as the public polarizes on any number of issues. To what extent is the Constitution itself the problem? If our politics don't seem to be working, does this suggest that the institutions and processes created by the constitutional text are somehow deficient? We might ask other questions, such as, is the Constitution sufficiently democratic? Is it able to achieve the governmental objectives that we deem important? Does it adequately protect our rights? Current diagnosis about the health of the polity ultimately turns upon such questions because first and foremost, the Constitution is an attempt to achieve the ends or goals of the polity that we aspire to together. And so it's in the context of this question that I'd like to invite our speakers to the podium to begin this discussion. And I do want to echo something that President McGadney said at the very beginning, that at the original debate that took place here, it really was a political contestation with real political stakes. Abraham Lincoln really did want to win an election, and so did Stephen Douglas. And it was winner take all. The conversation that we're going to have tonight really is multifaceted and nuanced. There are 8 dimensions, not 2. Our speakers might agree about certain things, but for different reasons, and it'll be in the context of their conversation that we might find common ground where we don't expect it, and disagreements that are unanticipated. And so I hope that you'll be inspired by the conversation that our speakers have with each other, and that you take part in that during the question and answer portion. The way our event will work tonight, both of our speakers will speak for around 20 minutes, and then we'll move to kind of moderated discussion between them before we open up to questions. And you'll find microphones to ask questions. I believe we've got people holding microphones. And I will move you, give instructions when we get to that point. So allow me to introduce our speakers, and then I'll invite them to the podium. Professor Julie Suk is an interdisciplinary and comparative legal scholar, researching equality at the intersection of law, history, sociology, and politics in the United States and globally. She's a professor of law at Fordham University College of Law. Her recent book, We the Women, The Unstoppable Mothers of the Equal Rights Amendment, is the first and only book to chronicle and assess the 21st century revival of the Equal Rights Amendment, culminating in Virginia's ratification in 2020. She's authored dozens of articles and book chapters about comparative constitutional law, the procedural implementation of equality norms in the United States and Europe, gender quotas, and women, work, and family. Following law school, she clerked for the Honorable Harry T. Edwards of the U.S. Court of Appeals to the D.C. Circuit. Professor Jeff Tulis is a professor of government, law, and communication studies at the University of Texas at Austin. His work intersects the fields of political theory and American politics, more specifically American political development, constitutional theory, political philosophy, and the American presidency. He is the author of a number of books, including the award-winning The Rhetorical Presidency and Legacies of Losing in American Politics, co-authored with Nicole Mello. 4 collections of essays on the rhetorical presidency with responses by Professor Tulis have been published, including a special double issue of Critical Review, where his book is described as one of the 2 or 3 most important and perceptive works written by a political scientist in the 20th century. And it received the American Political Science Association's Legacy Award in 2018. He has served as president of the Politics and History section of the American Political Science Association, and I should say also chaired my dissertation committee. So with that introduction, I'd like to welcome Professor Julie Suk to the podium to make her presentation. Thank you.
Good evening. I just want to begin by thanking President McGadney and Professor Bell for your hospitality and in convening this very important debate here at Knox College. It's certainly an honor of a lifetime for me to address you here today at the only surviving venue of the historic debates between Abraham Lincoln and Stephen Douglas in 1858. A central topic in those debates, and particularly in the 5th debate that took place here at Knox College in Galesburg, was the constitutional crisis that was wrought by the Supreme Court's decision in Dred Scott v. Sanford. The Dred Scott decision said that the Constitution excluded the possibility of citizenship for people of African descent. It found the slaveholders' right of property in enslaved persons in that Constitution that was signed in 1787, the signature of which we're commemorating through Constitution Day. At Galesburg, Lincoln grappled with his rejection of the Supreme Court's interpretation of the Constitution. He said, "I believe that the right of property in a slave is not distinctly and expressly affirmed in the Constitution. I believe that the Supreme Court and the advocates of that decision may search in vain for the place in the Constitution where the right of property in a slave is distinctly and expressly affirmed." And many years later, in 2022, we are in Galesburg again after another decision of the U.S. Supreme Court that many Americans strenuously reject and regard as a constitutional crisis, the June decision by the Supreme Court in Dobbs versus Jackson Women's Health. Dobbs overruled Roe versus Wade and said that the Constitution did not include a woman's right to terminate a pregnancy. Although there are very important differences between the Dred Scott decision and Dobbs, I will argue tonight that both decisions exposed the need for a new Constitution. Lincoln's grappling with Dred Scott in Galesburg and beyond, as well as his disagreement with the Supreme Court in the Lincoln-Douglas debates, led him to realize eventually that the Founding Fathers' Constitution was broken beyond repair. The solution was a complete remaking of that Constitution by extraordinary amendments that transformed and remade the entire document. The 13th Amendment abolishing slavery, the 14th Amendment defining citizenship to definitively include formerly enslaved people of African descent and guaranteeing them the equal protection of the laws, as well as the 15th Amendment prohibiting the denial of the right to vote on the basis of race. The constitutional crisis of Dred Scott was resolved by the emergence of what was essentially a new constitution for the United States, a second founding, as a long line of constitutional scholars and historians have characterized those three transformative amendments. It was a second founding, actually a second American Revolution, not only because the transformative amendments significantly altered the legal, political, and social order, but also because those revolutionary amendments were made without following the rules prescribed by the old Constitution for amendment, namely Article 5. Many scholars have noted that the 13th, 14th, and 15th Amendments may not have really gotten the agreement of 2/3 of both houses of Congress and 3/4 of the state legislatures, as Article 5 requires. That's because who counted as a legitimate member of Congress and which state legislatures were legitimate ratifiers were all seriously in question when doing this math, not to mention the rescissions of ratifications of the 14th Amendment. Nonetheless, even though the amendments that essentially gave the United States a new constitution may not have met the exact requirements of Article 5, they came to be regarded in the 20th and 21st centuries not only as legitimate, but as the pillars of American constitutional democracy. In the Dred Scott and Dobbs decisions, the Supreme Court declared itself powerless in the face of our Constitution's history, text, and traditions. The court said in Dred Scott that federal courts could not adjudicate the lawsuit for emancipation because federal courts lacked power under Article 3 over cases where the state citizenship of the litigants was not established. That adjudicatory power, of course, belonged to the states. In Dobbs, the Supreme Court says that federal courts don't have the power to protect a woman's right to abortion because that power belongs to state legislatures. Yet, while claiming to have no power, the Supreme Court decisions clamped down on certain human beings with tremendous power to shape their lives. The Dred Scott decision made it impossible for Dred Scott and other enslaved or formerly enslaved people to live as full persons in the South. The Dobbs decision makes it impossible for many women, especially women without resources, to live as full and free persons in many states, as abortion bans that are going into effect force women into motherhood in places where maternal mortality rates remain high and state support for mothers and children is low. But let's be clear, the outcome reached in Dobbs, like the outcome reached in Dred Scott by Supreme Court justices with too much power, is one that the existing Constitution allowed and enabled, hence the constitutional crisis in both instances. The constitutional crisis of Dobbs is not about abortion, or at least not only or primarily about abortion. In fact, I would argue that Roe v. Wade was also a constitutional crisis, not a constitutional triumph. Both Roe and Dobbs demonstrate serious defects in the U.S. Constitution's institutional design that make it unfit to govern a modern, pluralistic democracy. Both Roe and Dobbs demonstrate brute exercise of judicial power that flows quite naturally from a host of constitutional design features that no reasonable democracy would choose today in the 21st century. Right now, we have a Supreme Court majority that has imposed a new era of coerced maternity on women, that has cut off New York State's efforts to prevent devastating gun violence, and that has stymied the federal government's efforts to address climate change. The spare and capacious text of the Constitution has over-empowered life-tenured judges to enforce their interpretations of this spare text. Take, for instance, the 14th Amendment, which is the constitutional source of the values that Americans associate with our nation's proud identity as the leader of the free world, a place where people of all backgrounds, black or white, rich or poor, can pursue the American dream. The 14th Amendment guarantees equal protection of the laws to all persons and says that government could not deprive any person of life, liberty, or property without due process of law. Although this post-Civil War amendment and new beginning did not denounce discrimination against women, the Supreme Court eventually, 100 years later, broadened the interpretation of the 14th Amendment to include women's right to non-discrimination under the Equal Protection Clause, as well as the liberty right under the 14th Amendment to terminate a pregnancy under the Due Process Clause of the 14th Amendment. But in the very same way that the 1787 Constitution was a compromise between pro-slavery and anti-slavery Americans that made it plausible for the Supreme Court in Dred Scott in 1857 to invoke it to protect the slave owner, the post-Civil War Constitution was also limited in ways that make it logically sound today for the Supreme Court to say in Dobbs that the Constitution's text, history, and tradition do not afford equal protection of the laws to pregnant people or support all the liberties necessary to render women fully equal citizens and persons, such as the right to abortion. Like Lincoln, here in 1858, who wanted to believe that the Constitution, or at least the Declaration of Independence, recognized the rights of Black people to life, liberty, and the pursuit of happiness, I desperately want to believe, as Susan B. Anthony tried to assert in the 1870s, that the 14th Amendment's principles include the rights of women to life, liberty, and property, with regard to their wombs, as well as other types of liberty that men also enjoy. But that reading is not the only logical reading of the 14th Amendment, even though, to my mind, it is the most morally compelling one. We now have a Supreme Court majority that has a different reading based on the original meaning of the 14th Amendment in 1868. Of course, in 1868, when the 14th Amendment went into force, women were not recognized as equal persons or rights bearers under the law. But it's a Supreme Court majority that we have today in 2022 that resulted from design elements of the 1787, which were not abandoned or adequately fixed at the time of the second founding after the Civil War. And these design elements are anomalous in the world of 20th and 21st century constitutional democracies. No other modern democracy that we consider to be our peers has a life tenure judiciary, particularly on an apex court charged with constitutional adjudication and the power to strike down statutes. No modern democracy has a legislative body like the Senate that grossly overrepresents underpopulated states. No modern democracy has a president elected by an electoral college rather than the people themselves. All of these features by themselves would get a poor grade if we are evaluating these institutions by how well they enable we the people to govern ourselves through representative bodies. And working together, these design features produced a president who did not win the popular vote, an unrepresentative Senate that could delay one president's nominee after the unforeseen death of one justice, namely Justice Scalia, and then rush another president's nominee after the unforeseen death of another justice, Justice Ginsburg, creating the majority that resulted from the happenstance of untimely deaths rather than a rational democratic process. And by the design of 1787, the more representative legislative chamber, namely the House of Representatives, has no say in judicial appointments. It is only the Senate that confirms. Finally, the valve that the founders included, the tool, the amendment rule in Article 5 that would supposedly enable us to fix these defects and make a more perfect union, has actually become useless for such a huge country in the 21st century. One obvious response to originalist interpretations of the Constitution is to amend the Constitution. If the people don't want 18th and 19th century meanings to rule their lives, they can just amend the Constitution, right? If the Supreme Court has too much power, we can just amend the Constitution to impose term limits, for example, correct? Wrong. Our Constitution's amendment rule, Article 5, makes it very difficult to amend the Constitution in general and impossible to change the design of the Senate. Article 5 reads, in full, the Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution or on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes as part of this Constitution when ratified by the legislatures of 3/4 of the several states or by conventions in 3/4 thereof, as the one or the other mode of ratification can be proposed by the Congress, provided that no amendment which may be made prior to the year 1808 shall in any manner affect the first and fourth clauses in the 9th section of the first article. That would be the provisions on the slave trade. And then that no state without its consent shall be deprived of its equal suffrage in the Senate. The last amendment to the US Constitution was promulgated in 1992. The 27th Amendment requires Congress to wait until the next election cycle before making any self-rewarding salary increases that can go into effect. It is not a modern amendment. It was drafted by James Madison with the original Bill of Rights in 1789. When the Supreme Court purportedly returned the question of abortion back to elected legislatures in Dobbs, an obvious solution to Roe's demise would be for Congress to adopt legislation, such as the Women's Health Protection Act, or even amend the Constitution to make explicit the equal citizenship stature of women, or even an explicit right to reproductive freedom and autonomy. But it's obvious that efforts to protect all of these rights and the status of women are unlikely to succeed today, even if supported by most Americans, because even after the House passes such initiatives, the Senate routinely blocks legislation by filibuster. Even putting the filibuster aside, the Senate is not designed to be representative of the people equally. It's only designed to represent the states equally, regardless of how many people live there. If the Senate were proportionately representative of the American people, we today would probably have federal laws protecting abortion access, and also things like paid parental leave, pregnant worker fairness laws, more robust equal pay statutes, and other measures that would generally promote women's full inclusion in the polity as citizens, all of which the Senate has, in recent memory, filibustered. The Senate has also refused to act on the Federal Equal Rights Amendment, which was recently ratified, although somewhat late, by the state of Illinois. The Senate has refused to act on it following the late ratifications in a manner that would eliminate the ratification deadline. And it's worth noting that the ratification deadline on the Equal Rights Amendment, which was put in the early 1970s, was put in largely because there were a few powerful members of the Senate who dragged their heels on passing the Equal Rights Amendment. So changing this design feature of the Senate, that is, its equal representation of the states regardless of population, just simply cannot happen under the existing Constitution. Article 5 requires the passage of most proposed amendments by 2/3 of both houses of Congress, plus ratification of 3/4 of the states, which is very infrequently deployed because people do not see it as a realistic option. But even if that rule were to apply, Article 5 tells us that the equal representation of the states in the Senate cannot be changed. And there are some deep and severe consequences to our constitutional amendment rule. Even the ordinary Article 5 requirement, 2/3 of both houses of Congress and 3/4 of the states, makes amendment in response to Supreme Court interpretations of the Constitution essentially impossible. That's why we're not really seeing serious proposals to add reproductive rights amendments to the US Constitution in response to Dobbs, even though legislators in other countries, including France, are launching several bills seeking to add reproductive rights to their constitutions in response to Dobbs. Article 5 is basically a constitutional cage. It prevents the people from changing the Constitution to represent and govern themselves. And not surprisingly, the amendments that have been introduced to achieve greater inclusion in who counts as we the people, the 13th Amendment, the 14th Amendment, the 15th Amendment, which I've already mentioned, as well as the 19th Amendment on women's suffrage, all of these amendments have run into Article 5 problems. The 19th Amendment was challenged in litigation after it was ratified by 3/4 of the states, with some very learned men, in fact, a state judge who had training in law. He argued in litigation that any amendment that enlarged the polity so significantly by adding women citizens as voters would alter the equal representation of the states in the Senate and was therefore prohibited by Article 5. At the time, Justice Brandeis, an iconic liberal justice, rejected that argument, but a different court with different justices might have read Article 5 to prevent the 19th Amendment's addition to the US Constitution. This history should lead us to question the continued adherence to Article 5 as the sole path of formal constitutional change. Article 5 has prevented us from fixing the most undemocratic features of the 1787 Constitution, including most notably the over-empowerment of the Senate that is unrepresentative of the American people and that controls lifetime appointments to an over-empowered Supreme Court. That Supreme Court is basically in charge of updating and changing the Constitution because people do not regard constitutional amendment under Article 5 as a realistic option. As a result, legal elites figure out a way to litigate interpretations of the Constitution, and we get constitutional change through the judiciary rather than through the people. Perhaps we can begin by trying to make Article 5 a little bit more democratic than the founders imagined. Legislatures around the world, in countries like Ireland and Iceland, have innovated processes by which citizens' assemblies are convened. Randomly selected groups of citizens deliberate on constitutional amendments which then the legislature proposes and adopts or votes on. Article 5 doesn't say anything about this, but there's no reason why Congress couldn't convene such deliberative assemblies and use them on an advisory basis to get a gauge of what the American people want in terms of what the Constitution for the 21st century does and says. As a general matter, the exercise of drafting a new Constitution, that process, whether it becomes law through Article 5 or other legitimizing means, is essential to shifting our imagination about what a Constitution can or should be in the 21st century. And we, the American people, deserve a new Constitution for a real chance at democratic self-governance now more than ever. Thank you very much, and I'm going to turn the floor over to Professor Tulis.
Thank you very much. The lights are on me, but not on my paper, so I'm going to have to remember what I wrote down. I can't see it very well, but I want to begin by thanking everybody for coming, and I want to thank the president for arranging this event and for Thomas as organizing it. I agree. I am at one with Julie that this is an honor for both of us to be on the same stage that Lincoln and Douglas were on. And it's also an honor for me to be coming to Knox College in Knox County, from where I live half the year in Maine, which is Knox County, Maine, where the same Secretary of War, Henry Knox, lived and whose mansion exists, although not in the spot where he lived in it, called Montpelier, the same name that Madison gave to his mansion. And Madison will figure in a few minutes in my remarks. Now, the expectations that one might have, and this has been covered a little bit by the president and by Thomas, expectations that you might have about a debate like this might include the notion that somehow there would be this clash between us, this disagreement on the points that were raised. And I did take notes, by the way, on what Julie just said, because while consistent with what documents that we shared with each other, she has an elegant and nuanced new take on some of these issues that weren't covered there, and I have to sort of think a bit on the spot about what I think about them. But in general, I agree with much of what she says. And the reason a debate like this is different than the Lincoln-Douglas debates, or different than other political debates, is because what we're called upon here is not to decide something, but to think about things. And so this is more like a conversation than a debate. So I agree with Professor Sook that about every point that she made about the infirmities that we witness. The problem with the court, the problem with the Senate, the problem with the Electoral College, the problem with the amendment process. All of that is right, and I'll say a bit more about this in a minute because we both were part of a collective that imagined a new constitution that was published in the magazine Democracy that addressed some of these issues and others. And I joined that collective and participated in that project because I do agree with so much of this. But what I'm going to talk about today is not so much an antithesis to those points, but a suggestion that the constitutional crisis that we face today goes much deeper than the institutional points that Professor Sook so articulately described. Let me start with what she did say as an introduction a little bit into that. She made this elegant comparison between the Lincoln's response to the Dred Scott decision and most intelligent commentators' response today to the Dobbs abortion decision. What's striking is both of those decisions are patently wrong with respect to the Constitution, and in the case of Dobbs, with respect to constitutional law on the subject. Both of them are just simply wrong. And the reason that they turn out, the reason then that Lincoln and the opponents of Dobbs turn out to be allies in the project of fashioning a new Constitution is the wrong decisions prevailed. The wrong decisions prevailed. And Professor Sook makes a very good case that they prevailed partly because of the structure of the court. Now, they don't inevitably prevail because of the structure of the court, and she had to segue a little bit to talk about Roe, because after all, Roe articulated the relationship of the right to privacy that had previously been established by the court to the issue of abortion. And so Roe, one could say, was rightly decided. The same structure produced a good result and a bad result. Now, the reason I say all this is that raises the problem of the imagination of a new Constitution and the unrealistic hope that any new Constitution will never frustrate good interpretations. So in other words, Lincoln didn't wrongly interpret the Constitution. He had the right interpretation. And of course, Dobbs is the wrong interpretation. Well, in any imagined new Constitution, you could have right decisions and wrong decisions prevailing or not at different times. The reason this takes me to my next point, and the deeper issue here, is that the reasons that these decisions prevail in some cases, and the reasons changes actually were forthcoming in the past, as Professor Sook so articulately described, has to do with something deeper than and more important than the institutional arrangements of offices and powers and the articulation of rights in the Constitution. It has to do with the civic virtue of the citizenry. It has to do with who we are as a people. Now, we don't normally talk this way when we're talking about the Constitution. We normally talk the way that Professor Sook talks about the Constitution, in a very legalistic way. But the Constitution as designed was a political project designed to bring into being a whole way of life, a way of life that, if structured properly, would include among its various components, many of which have no explicit mention in the Constitution, such as the kind of economy we have, the kind of occupations that are favored in the United States, the kinds of things that Tocqueville talks about in Democracy in America. The Constitution brings into being all that stuff, but ideally would bring into being the kind of citizenry that could advance the best interpretations of the Constitution. So when Professor Sook asks, well, why did the Constitution, how does the Constitution frustrate its own best intentions? Part of the reason is not just institutional arrangements, it's the actual civic virtue of the people. And the best evidence that I can give for this are the two instances which of constitutional revolution, one could say, that the United States has previously experienced, and that one of which was alluded to by Professor Sook. Those two experiences were the making of the Constitution itself to replace the Articles of Confederation and the Civil War Reconstruction Amendments, which Professor Sook says many people, she included, maybe me, I'm not exactly sure on this question, think of as yet a new Constitution. When I say I'm not exactly sure, it certainly improved the Constitution. But to make a new Constitution, one has to change it in its fundamental characteristics. And Lincoln's argument, in effect, was that most of what's in the Civil War Reconstruction Amendments was already implicit in the Constitution. So whether the Civil War Reconstruction Amendments are, as Bruce Ackerman at Yale and other people say, a true constitutional revolution or not is somewhat of an open question. But let's assume that it is, just like the Constitution was in replacing the Articles of Confederation. What is striking in both of those instances, that at the moment of failure, institutionally speaking, in the case of the Articles of Confederation, it was the inability to raise money to support the national purposes of the government, or to raise men and material for war, the complete inadequacy of the arrangement to the purposes of the Articles of Confederation that summoned a diagnosis and a proposal for this new Constitution. Now, what's so striking is that there was a citizenry capable of understanding those arguments, capable of appreciating those arguments, and capable of actually doing the sorts of things that Professor Sook rightly recommends that we do now. You know, in that first, our own Constitution, the capital C Constitution from 1787, that Constitution was illegal by the terms of the amendment processes of the Articles of Confederation. So this is perfectly consistent with Professor Sook's argument that we shouldn't feel some sort of unbreakable fidelity to the Article 5 provisions of our Constitution. The interesting difference is that the citizenry was capable of understanding the arguments at the time for making that kind of fundamental constitutional change. Now, the same argument could be made with respect to the Civil War Reconstruction Amendments that Professor Sook mentioned. And here I'd like to also invoke, as she did, the Lincoln-Douglas debates that took place here at this very spot. I was talking about this matter with the president and others at lunch today. It's truly remarkable, if you read those debates today, just how sophisticated they are. They are actually far more sophisticated than we have the time and maybe ability to do in our conversation with you here today. But one can't imagine the American citizenry today. I'm not talking about the Knox College and Galesburg community. I'm talking about the American citizenry writ large. One cannot imagine the citizenry sitting still today for anything analogous to the Lincoln-Douglas debates. So at the very moment of that crisis, that constitutional failure, was summoned an inner strength of a people beneath the failure of institutions and court decisions and policies and so forth. That's what I mean by civic virtue, and that's what I mean about a need to think about constitutions and constitution making more deeply and more broadly. And so I want to say a few words about what I mean by that. One thing that we didn't talk about explicitly, but I have a feeling from other things that we have spoken about in other venues that Julie Sook and I would agree on, is that it is a problem today to venerate the founders, to venerate them in a kind of unquestioning fidelity. One needs to question, to think about, to talk about, and to challenge the founders' project, especially if it's thought of in sort of narrowly originalist terms. But there's a very different way to think about the founders, and a very different way to think about Lincoln, for that matter. And that's not to imitate them or to venerate them, but to emulate them, to think about constitutions the way they thought about it, if we're thinking about amending our own or making a new one. And so I just want to say a few words about how they thought, what they thought in that sense, how constitutional thinking itself is different than what most American citizens imagine it to be today. They thought, first of all, let's go back to the fact that constitutions are much older than our Constitution. but they were generally small c constitutions. They were the way that polities actually functioned. And one of the amazing achievements of the American founding and the founders, and by the founders I mean the smartest of the founding generation, so on the Federalist side it would include Hamilton and Madison, but also anti-federalists like Robert Yates, who people imagine was Brutus, who has the smartest writing on the judiciary at the time, who predicted a lot of the problems, by the way, Brutus did, that Julie articulated. And Mercy Warren, a woman who was an anti-federalist and one of the most lucid and intelligent of them. These smart, far-seeing people had a different way of thinking about what a constitution was. So to give you a sense of what I mean by that, let me just say a little bit more about, just for 2 minutes, about this project that Julie and I participated in. There have been a bunch of conservatives who've gotten together and said, here's some amendments to the Constitution. And they have generally been tweaks that in many of our views don't really improve the Constitution very much. So the editor of this magazine, Democracy, a Journal of Ideas, got together with a friend of ours, Sandy Levinson, and said, why don't we bring progressives, broadly speaking, together to imagine a new Constitution for the United States. And that's what happened. And it spent months doing it. It was very, very interesting. I think everybody would agree that it would be a good exercise for citizens to do generally, even if nothing results in concrete change to the polity, that the thinking that it induces would be good. The people were very public spirited. They acted in good faith. It was a good conclave, although virtual conclave. But Julie supported the result, the product of this thing, and I dissented from it. Why? Because I imagined that the progressive Constitution would be the Constitution that one wishes everybody had, irrespective of partisanship, whereas the conservative Constitution was an overtly conservative product. And what came out of this conclave was a listing of rights and other provisions that entrenched preferred progressive policies into a constitution, gave them constitutional status. And in my view, that undermines the fundamental objective of the progressive Constitution, which was to make our Constitution more democratic. Because if you make progressive policies just the way things are, constitutionally, there is no agency left for ordinary citizens to decide what our policy should be. And quite frankly, if we have a general purpose, for example, to secure the general welfare, that includes the possibility of something like a welfare state, but it also includes the possibility of something the opposite of that, a privatized order, as long as the defense of the privatized order is that it's better for the general welfare. That's a good partisan debate to have, and quite frankly, at different moments in our history, I might be inclined, given the social and economic configuration of the times, to side with one side or another in a partisan sense. So you don't want to nail down partisan positions in constitutional terms. So a constitution's something different. With respect to the offices and powers, it sets up mechanisms for democracy to be a democracy, which is to have robust debates and not to foreclose them by the Constitution itself. But it's a bigger project than that still, and I want to end pretty much with this on the point that I began with about a Constitution being an attempt to create a whole polity, a whole way of life. So the conceit and the amazing success of the American Constitution was to take and model for the world, despite the fact that the provisions like the presidency and the court and stuff are not being imitated anymore, as Professor Suk pointed out. What has been a model for the world is this idea that somehow you could take the two-dimensional written form, the capital C Constitution, and actually make a small c Constitution, make a people with a particular way of life, a particular set of habits and characteristics, a particular way of doing things, and a particular way of understanding who should rule. How did the founders think about that? Well, they thought about the Constitution then not just as a settlement for their own time, but as a plan for the future. So the Anti-Federalists opposed the Constitution because they agreed that the proposed Constitution had this future-oriented political logic to it. They were not originalists the way they are invoked today. They all thought that we would have a strong presidency over time. They all thought that we would have a strong and powerful judiciary over time. They all thought the country was going to get complicated, big, pluralistic, and messy, much more than it had been, and be increasingly urbanized all the time. The Anti-Federalists didn't like that, and so they opposed it in normative terms, but they agreed that that's what you would get if, in fact, you adopted the Constitution. The Federalists, for their part, were put back on their heels because ordinary citizens were being introduced to the proposition that something really big and bold was being proposed here. So they iterated their argument, initially saying it wasn't as much of a change as it really was, and then eventually gave a sophisticated version of the point the Anti-Federalists made, that yes, it would be big, yes, there would be a standing army, yes, the judiciary would have judicial review, and so forth. And what has happened over the course of American political history that has given purchase to this regressive tradition, this anti-constitutional tradition that has undermined it over time, is the exploitation by the Anti-Federalists and the heirs of the Anti-Federalists of this iterative process of the Federalists, so that they would, over history, read back the early iterations of the Federalist argument, the ones that were attempt to mollify, and ignore the sophisticated ones. That's what originalism actually comes down to often. Now, so that's one of the deep sources of our problem, this long history of anti-constitutional invocations of the Constitution. But I want to end by saying that one of the things that struck me in preparing for this and even listening to Professor Sook is just how we're not facing what is, it's a bad pun, but the elephant in the room. We're just not facing up to how significant a crisis this Trump and Trumpism phenomenon is. Far, in my view, far more serious, it's a far more serious danger to the Constitution than the Civil War crisis was. And it's a far more serious crisis than the crisis announced at the founding of the Constitution. There's been nothing really like this. The only thing even close to a Donald Trump that we've had in the past was Andrew Johnson, who was not elected and who was run out of office by his own party, as well as the party opposite. Now, what we have today is simply Orwellian, as all of you well know. And it's so Orwellian that ordinary citizens can't come to even label it comfortably. We have a large proportion of the country that are overt supporters of something that is not only anti our Constitution, but anti-constitutional, anti-liberal, that is liberal democracy, opposed to everything we stand for. That's why at the very beginning of the Trump phenomena, some political scientists and others said, and philosophers like Jason Stanley and historians like Tim Snyder at Yale and others, that we have to talk seriously about the possibility of fascism in the United States. That got tremendous pushback. Why? Because, well, there are lots of different kinds of fascisms, and we're not, you know, it's a stretch to say that Trumpists are Nazis, even though there are some comparisons one could be made in the use of language by Nazis and so forth. We're not Nazis. So, but Umberto Eco, the great Italian thinker, pointed out that fascism is the result of a series of family resemblance characteristics. If there are fascists all over the world, there are 14 different characteristics they have, and every one of them only has a different 4 of those 14, because fascism aligns with the regime that it corrupts. Well, you know, this was something that it was very, very hard to absorb in this country. And because of that, it's not just Trump supporters that are a problem. It's the sort of meekness and acquiescence of most of the country, most of the time. Our current president has awakened to this issue, and that's why he, again causing an uproar, came up with the term semi-fascism. It had to be said. I end with this because this problem is so serious that it cannot be solved by just changing the, by the way, I'm for changing the Electoral College and the court, and I'm for everything Julie's for almost. That won't solve this problem. That will not solve this problem. Only thinking through how it is that the anti-federalists might have been right, that this country from the beginning did not give enough attention to civic virtue. Now you might say, well then why were they so virtuous at the Lincoln-Douglas debates? I've thought a lot about that. It may not have been because of our Constitution. It might have been a residue of a pre-constitutional political project that relied much more on direct education and inculcation. Our Constitution is predicated on the elevation of self-interest, the transformation of self-interest, the institutional structuring of self-interest, and only gives a modicum of attention to the need for virtue, by which I mean both competence and decency. The constitutional project of finding virtue just shows you how difficult the present crisis is today. Thank you very much.
Thank you both, Professors Julie Suck and Professor Jeff Tulis. What we're going to do now in this section of the conversation is to just have some discussion before we move to Q&A. And we can't actually see you in the audience with the lights. I believe that there will be people with staff with microphones, and so when we turn to the Q&A portion, I believe you can raise your hand and they will bring a microphone to you. If I'm wrong about that, someone let me know. But before we turn to the Q&A, I just thought I would invite you two into conversation with each other. And Jeff, since you just finished, Julie, I thought I'd turn it over to you and see what responses you might have or questions you might have to Jeff, and just get a conversation kind of rolling between the two of you.
So great. Thank you so much for your remarks, from which I learned a lot. So I wanted to just pick up on 2 points. One is this debate, on which we may have a real disagreement that we're probably not going to resolve tonight, and it's about how we characterize Dred Scott as wrong, and or Dobbs as wrong, and or Roe as correctly decided. Because I agree with Jeff that if our yardstick is some kind of moral reading of the Constitution, then I fully agree that Dobbs is wrong. But I do think that in our system, in a pluralistic and ideologically diverse place, there are a lot of disagreements as to how the Constitution should be interpreted. And I cannot say, based on the text, the history, and the doctrines, that Dobbs is obviously wrong, or that Roe is obviously correct. And Dred Scott, I think, Lincoln in Galesburg says that, well, the Constitution really doesn't protect property in slaves, but I think over time he came to see that the 1787 Constitution, regardless of that particular question, was at its core a compromise on the slavery question that he thought was incompatible with his moral views on slavery. And I think once you see it that way, then Dred Scott is correct if the measure is the 1787 Constitution, but perhaps incorrect based on a moral reading of the principles that you hope were shared by those who adopted the 1787 Constitution. But I think it's because this is a very difficult disagreement to resolve One obvious solution would be when we can't agree on the right interpretation, let's just amend to be explicit. But if you live in a system in which amendment is pretty much off limits, then that's where I think I locate the dysfunction. That then we come to rely on the Supreme Court to make updates and changes rather than a healthy amendment process. And I think this point also goes to this question of civic virtue. I think today one might see, I completely agree that changing the Constitution is not a sufficient condition of averting the constitutional crisis that we're in. I'm not entirely confident that it would go away, but I do think that there are some tools that might make our culture of engagement and political engagement better. I think part of the reason you see a lot of disengagement is precisely because of the Electoral College, where presidential candidates don't campaign except in purple states or so there are a lot of ways in which the features that we have, including Article 5, we don't actually imagine amendment as a solution to problems with regard to interpretation. And I think all of these things taken together actually contribute to the decline in civic engagement that you see. I don't think they're the only explanation for where we are today, but I certainly think that changing some of these things could help.
So, can you hear me? So again, I think we agree, but I want to bring out the disagreement part. Okay, what we agree on is, look, there are all these different ways that people interpret the Constitution, and they go up and down with respect to the court's use of them. And I was just saying, well, that's going to be true in your new Constitution too. So that was my basic point. But I do want to pause a minute on the notion that there was a right way and a wrong way. And it does turn exactly on what Professor Sook says. That means you're saying that the moral reading, that style of interpretation, is the correct one, and the originalist reading is incorrect. Because if you follow an originalist reading, you might be able to muster evidence for each of these propositions. That's exactly what I'm saying. And one of the interesting things is that the vast majority of the legal academic community, both in the law schools and in political science, have long ago said that the originalist method and the originalist understanding is indefensible, basically. It's not defensible, and most have said some version of a moral reading is the only defensible reading of the kinds of clauses that lend themselves to a moral reading. What is a moral reading, just for the audience? So Ronald Dworkin was one of the most famous of this. It wasn't the idea that people had to share a conscious understanding of all the moral implications of their views. It was rather that if they had a particular moral concept, a moral idea, conception, I should say, a conception of how to do things, a conception of what justice was, a conception of what equality was, that given a choice of their conception, that is what they thought at the time, or the better version of it, the concept of it that their conception was a hypothesis about, they would choose, if posed, and if they were true to themselves, the concept. And the example that Dworkin gives is this. Suppose you want to be a good mother or a good father. And people sometimes say, well, that means I'm going to do it the opposite of my parents. Or others say, I want to do it just like my parents. But you have some conception of what it means to be a good parent. You have something in your head. That's the conception. And that's the equivalent to what the originalist is looking for and tying things to. What was their conception? Were they prejudiced? Were they this? Were they that? And Dworkin says, look, but wouldn't any parent, if faced with the proposition, look, I know you've been doing it this way. I know you think that's the way to raise your kid, but it's hurting your kid. Read this book. It tells you why. And this book shows you, with data, with whatever, that there's a better way. Your kid is going to be happier, more, you're going to be happier if you do it this other way. That's the concept. Or that's another conception that's closer to the concept, which is I want to be a good parent. So the shared idea is I want to be a good parent, and the conception of what that means gives way to subsequent conceptions that seem to come closer to the concept. That's the Dworkin idea applied to constitutions. And what that means is that meanings that we take today may have been there all along, even if the people didn't fully understand it at the time. If we went through a similar exercise like this, they might be brought to understand, but it's implicit there. So that's the argument that one really is better than the other. But my point wasn't that. My point was, because I think that you think that some are better than others, and I'm just saying that, look, you're going to be disappointed because any constitution is going to have the same problem that you've just articulated. That's all I was saying. This problem of multiple interpretive modalities.
Well, actually, I disagree with that.
Yeah.
Largely because, I take your points that you were making earlier about rights interpretation as lead, especially with these open-ended concepts, and the provisions on rights being giving you pause with regard to the Constitution that we drafted for the Democracy Project. Because I think that when Hans Kelsen introduced the idea of constitutional courts in the European context in the early part of the 20th century, he actually did not think that constitutional courts should be in the business of enforcing rights. And it was in part because it would turn the constitutional courts into more of a legislator. Although one of the good things about Kelsenian constitutional courts in the European context is that they have the power of judicial review, but the judicial review process is designed in a way that leads to more of a dialogue between the apex court or the constitutional court and the legislatures. But here in the United States, I think part of the problem with a moral reading is not that it's a bad way about things. It's just that you have the Supreme Court empowered to strike down statutes, which itself also, it's not really clear before you get to Marbury versus Madison that had to be part of the original 1787 design. That said, in the European context, the notion that you can strike down statutes before they go into effect, and it engages the legislature in a process, or there's a deference to legislatures because you see the legislature as itself also engaged in a project of constitutional interpretation. That is, you can design judicial review and the court that does judicial review in ways that recognize that we, the people, and the legislatures also have valid and contested moral readings of the Constitution, whereas I think that the American design, not only, whatever the interpretive philosophy is, this notion that you're going to have a court that has this power to pretty much attain supremacy with regard to contested interpretations of the Constitution. I think that's the real problem, and I think that the design of post-World War I and particularly post-World War II constitutional courts after Nazism and fascism were attuned to this need to, on the one hand, have human rights adjudication, but on the other hand, to prevent institutions or particular actors from becoming over-empowered.
So our own country has changed to the problem that Professor Suk just articulated of over-judicialized decision-making from a polity that was much closer in many respects to the one that she prefers. I didn't get to talk about this, but you have an expert on your own campus. Thomas did his dissertation on these topics. And the idea is that in the 19th century, the legislature, the Congress, had a much more robust sense of its own role as a constitutional interpreter, as did the president. In the late 20th century, both of those institutions have deferred, indeed abdicated, to the courts, and therefore enhanced the court's authority. So that's just something you might want to think about, because we've actually tried this in the United States, and it sort of it worked actually at the time, but it has devolved. It is decayed, and one has to ask why. And I think that's connected a little bit to this question of civic virtue. But going back to what our purported disagreement is, I think it just shifts the venue. It's still going to be the case that there are arguments wherever constitutional argumentation takes place about what the Constitution means. And there may arguably be better and worse arguments in those debates, and sometimes the worst ones are going to win out, no matter what Constitution you design.
I wonder if we have any questions in the audience. It's 8:10, so it's probably time to maybe let the conversation be guided by you. So we welcome any questions. We ask that you would state your name. And if you're a Knox student, say that you're a Knox student. If you're a member of the community, just tell us that you're a member of the community. We'd just like to know who's speaking to us. And so we've got 2 members of the staff holding microphones. Do you need my microphone? I'm going to hand my microphone over.
Okay. I'm Helen. I'm a Knox student, and I'm sure it's really shocking, Professor Bell, that it's me asking the first question. My question was that I would like you earlier. You said, "quote I'm for almost everything that Julie is almost." Could you elaborate a little more on what those distinctions are and exactly why you believe that?
You're asking me what are the things that I don't agree with? Is that what you're asking me? I mean, there aren't that many, to tell you the truth. There really aren't that many, because we didn't really get into, and I'm glad we didn't. We didn't get into the sort of practical details of change. And I think we both agree that there are all sorts of prudential judgments that are difficult, that have nothing to do with this argument about what would be better, all right? We once talked about how, for example, there's been some talk about within the Article 5 process, there's the possibility of a constitutional convention like the original one, rather than proposals, from the Congress or from the states. And, given, and this touches my civic virtue point, given the character of the country now, who knows what would come out of such a constitutional convention? We don't have the Madisons and the Lincolns and the Hamiltons anymore. So we didn't get into that, but that's something that I think we agree on in general. But then when you get down into the weeds, of course, which I don't do much, but if we did, we might have different judgments, and reasonable different judgments about when to push here and when to push there, and what to try now and what to try. Those kinds of things just are good disagreements to have, but I expect them. While you're coming to the microphone, can I ask our talented technical people to turn the lights down a little bit? It's a little bright for us. Thanks. Thank you. Thank you.
Excellent, thank you. My name is Gavin Lockard. I'm a student here at Knox, and in this great country, there is still unemployment, there is still homelessness, and there's not a single municipality in the entire country. And so the question that some of us have is, will you support FDR, adding FDR's economic Bill of Rights to the Constitution, right to housing, right to health care, right to a job, etc.?
You want to go first on that?
Yeah, so many constitutions around the world have positive social rights. A lot of constitutions that were drafted in the 20th century after World War II have those rights. And I think it's created some challenges with regard to the enforcement of those rights, particularly in countries like South Africa, where those rights are protected on the one hand, but judges need to pay attention to the realistic possibility once it's declared that those rights need to be enforced, as to who's going to have the resources in some pragmatic way to make those rights real. And I'm not saying that that's insurmountable, but I think that is a challenge that many constitutional and apex courts have worked on. I think in the United States, unfortunately, every time the Supreme Court has been invited to interpret rights like equality or liberty in that positive direction, the Supreme Court has really stopped short in cases like DeShaney in 1989. They stopped short because they're worried about judges entering into what they see as a legislative function. So I do think that having those rights probably requires also having some way of directing courts and legislatures. You could also imagine having a constitutional provision that makes it not necessarily a judicially enforceable right. So there are rights in other countries or that are not really rights. They're more the legislature shall ensure. And so that makes it so that it's the legislature's job, but there's a question mark on whether or not if the legislature doesn't do it adequately by one's rights, whether you would have a cause of action in court in order to enforce it. So, but I do think another question that we haven't gotten into, which I imagine we might disagree on, because I think there's a lot of room for disagreement, is what would it mean to put such a, if we were actually if we were to have something that's not merely an academic exercise like the Democracy Journal Constitution that we both worked on, but you're actually trying to draft something that could somehow become legitimate, whether because you wanted it to be adopted under current Article 5, 2/3 of both houses of existing Congress plus 3/4 of the legislatures, whether it would be wise to put such a provision in a draft constitution, or any other legitimizing mechanism, because I think it's just a necessary part of any new constitution that eventually it has to be drafted with an eye to being adopted by whatever the legitimizing rule is. And I think a word of caution on that is what happened in Chile. In Chile, they wrote probably one of the most ambitious progressive constitutions in the world, with all of those social rights, a right to reproductive autonomy, a right to sport, many, many rights. And it was drafted by a constituent assembly of mostly political outsiders that were elected when only a little over 50% of the Chilean people showed up to vote for the assembly. But it was mandatory voting required for approving the Constitution. And in the September 4th referendum, that very progressive, ambitious Constitution was rejected by 66% of the vote under conditions of mandatory voting. I don't regard that as a total failure because I think it's actually a productive exercise to get down on paper what one's ideals are. But I also think that eventually, once that's been, that process has worked itself out, it's very important to draft a constitution that people in a diverse and pluralistic society can agree to live under. And I can see without a lot of work in terms of working out what that actually would mean, how such provisions may not be accepted in the civic culture that we live in the United States right now.
So I think that's a great question. Let me try to get past the lights and see if I can even see where you are there. But it's a great question, and but I think by formulating it the way you did, it seems to require only one answer. When in fact, I think I would agree with you and Professor Sook that the problems to which you attach the FDR Bill of Rights are genuine problems that it is imperative that a country like ours be designed to solve. There's no question about homelessness and so forth. It's imperative that we have a polity that's designed to solve those problems. Then the question becomes, well, are they best solved by conceptualizing them as rights or conceptualizing them some other way? This is some of the stuff that we were just talking about. But even if you think of them as rights, there's the further question of how best to secure rights. And there's a lot to be learned even from the founding of our own Constitution that didn't have a Bill of Rights to begin with. And Hamilton and others argued that it would be better for rights not to have a Bill of Rights. It wasn't that the Constitution wasn't committed to rights. It was that the Bill of Rights mechanism wouldn't be as good as a jurisprudence, for example, that developed around power and its limits, or a jurisprudence that developed around the Republican Guarantee Clause that we already had in the Constitution. A number of the points that Hamilton made included, for example, once you start listing rights, it might suggest that things not on the list aren't your rights. And so that's why we got the Ninth Amendment to the Constitution, because that argument was so powerful. But the point Hamilton was making was even more powerful because the court has ignored the Ninth Amendment for the most part, and routinely says that if something is not listed already as a right, you don't have it, even though it's perfectly willing to find implied powers that are not listed in the Constitution. So these considerations raise this panoply of thoughts that I'd like you to take home, I hope, that it's imperative we solve the problem you identified, the problems that you identified, but how to do that, constitutionally speaking, is a really tough nut to crack, and there are multiple routes to try to solve that problem.
Hi, my name is Daniel, class of 22. If it is common for democracies to amend their constitution, and it's been decades since the United States amended our constitution, should we address Article 5, and how should we?
Well, I think Professor Sook already said that there are ways to go around Article 5. That's one way to address it. But perhaps your question is, if you had a new constitution, what would you have instead of Article 5? I'm not sure I've given a whole lot of thought to that. Let me just say that there's one thing that Article 5 signals that I like, despite its unworkability in general. It signals that there may be such things as unconstitutional constitutional amendments. That is, people propose amendments. In the case of Article 5, it explicitly says you can't change the Senate. It also said you couldn't change the rule on slavery preventing the passage of a law that would prevent the importation of slaves for a period of years. You couldn't pass a law, the Constitution said, and you couldn't amend that provision, the Amendment Clause says. So these are entrenched provisions that can't be amended. Now, those particular provisions, we wish they could, well, one of them died, but we wish they could be amended. But it signals the possibility of things that are not mentioned by Article 5 that can't be amended. They would be things that are so fundamental that to change them would be to change the Constitution. So if you really thought that about the 13th, 14th, 15th Amendments, for example, they would be unconstitutional constitutional amendments. Now, the reason I think that's an interesting and important insight and provision and way to start thinking about things is it's not just an academic exercise. The reason that you want unconstitutional constitutional amendments is you want a polity alert to the proposition, when am I reforming something and when am I revolutionizing something? When am I making something new that I didn't have before that's different? And when am I improving the thing that I already have? And the reason that's important is because if you want to be a reformer, the politics of reform are completely different than if you want to be a revolutionary. So you don't want to do revolutionary tactics to reform, and on the other hand, if revolution is called for, reformism is not enough. So you have to have a civic understanding of that distinction, and the unconstitutional constitutional amendment conundrum is a way to get at that.
So I think there's substantively, if we could change Article 5, assuming that we would then subject it to the Article 5 amendment process, but we could change it. I think one model that you see in a lot of state constitutions is passage by the legislature, sometimes by a supermajority, but even by a bare majority, and then a referendum by the people. In New York State, in my state, it's passage by the legislature by a bare majority, but in 2 separate legislative sessions before it goes to a referendum by the people. I think that's a very common formulation. In many other countries, it's either passage by the legislature and then a referendum, or sometimes supermajority and extra procedures. So it has to be read and debated a certain number of times before a supermajority of the legislature passes the amendment. I think all of those would be better options than what we now have. I think there's also been a lot of innovation around using citizens' assemblies at the front end, not just the back end with a referendum, but at the front end. So the citizens' assembly deliberates and makes recommendations to the legislature, which passes. Now, all of these things, because I think it's hard to imagine any of these rules passing the Article 5 requirement. One is to have a more robust conversation about the ways in which Article 5 is just one of several options for achieving legitimacy of constitutional amendments. And I think the experience with the 13th, 14th, and 15th Amendments and all of their Article 5 irregularities points to that being something that we should be comfortable with here in the United States. I think the other problem is that if you look at the history of why Article 5 has been so hard, so one that I study, an amendment that I've spent a lot of time studying is the Equal Rights Amendment. And there you see where Senate, Southern segregationists actually, really insisted on that 7-year deadline, even though it probably would have passed the Senate without the 7-year deadline. But in some ways, a lot of roads as to why there was also an amendment to reform the Electoral College, essentially to get rid of it, which the House passed, but it got filibustered in the Senate in the early 1970s. So you might say one way to start with Article 5 is try to reform the Senate, which you can't. I think one way that you can maybe reform the Senate under Article 5 by subjecting it to the ordinary 2/3, 3/4 rule is by abolishing the Senate altogether, because if you abolished it, then they would all be equally still the states would still be equally represented. And I think you could subject an abolition of the Senate amendment to the ordinary 2/3, 3/4 rule. So one question is, if you were to propose an amendment that said, let's just strike the last bits of Article 5, we should strike the slave trade 1808 provision just because it's sunset anyway, and it's a little bit of a stain that's the thing we chose to make unamendable in 1787. So if we strike that and strike the Senate provision and we submit that to an ordinary Article 5 process, do I think that could possibly work? Maybe, although you still need to get it passed in the Senate under Article 5. In order for that to work. But I think that those might be some ideas procedurally as to how we might get past the Article 5 cage, assuming that once we could get past it, we should look at the many more reasonable amendment rules that are used in our state constitutions and in many constitutional democracies around the world.
Let me say a word about Julie's example early on that you called for on an alternative to the Article 5 that has been used in other countries and so forth. What I find interesting is it illustrates the proposition that there is always some unconstitutional constitutional amendment. Take any of those democratic processes that she described. If you went through those processes the way they prescribed, pretty much you could do anything. So you could, for example, change those processes slightly, say. But suppose you went through all those processes and said, we're not just going to change the processes, we're not just going to add a new right, we're not going to make a new institution, we're going to change the amendment process itself, the process we're engaged in, if we get enough votes, so that only one person gets to amend the Constitution, or only one religion gets to decide, or something like that. That would be an unconstitutional constitutional amendment by the lights of the fundamental value of the amendment process itself, which was democracy. So,
well, in other countries, of course, what's made unamendable, as in Germany, for example, human dignity. You cannot take that out of the Constitution. So I think the idea that there's always either explicit or implicitly certain things that cannot be amended, I think, is a very important one.
I'm going to take the moderator's prerogative and ask the last question. And as you finish answering that question, I'll invite Mike Snyder to come up and close us out. But I wanted to turn us back to kind of the question of civic virtue and the requirements of constitutional citizenship, because I think you've both kind of illustrated that maybe some of the problems with our Constitution are much more fundamental than the institutional arrangements that we have. And so I want to ask a question kind of specific to Knox College. We're a college community, all taking part in some way in American politics, either as citizens or as international students who are here at Knox College. But my question for you is, how would you encourage the Knox community and then by extension the national political community to how would we instill habits of civic virtue in ourselves and solve some of the problems that you think are much more fundamental? And then I know that's a hard question. And then as you wrap up, I'll invite Mike to close us out.
I don't know that I have something specific to the Knox College experience, but you can adopt it if you wish. I was always perplexed by something Tocqueville said, because he said at some point, rights are virtue that has come to the modern world. And I never understood that initially, because rights were the replacement to some degree of virtue. So in other words, our rights emphasis replaced virtue. And he said, no, but it is a new kind of virtue. And what I came to understand that he meant was in the 1830s, when he wrote, and around the time that this college was founded, I guess, Americans, he believed, so cherished rights that they cared about the rights of their fellow citizens. They didn't care just about asserting their own. And so there was a sense of civic engagement and caring that was compatible with liberalism and liberal democracy. And so I think you have to start to think that way. How can my individual aspirations for a career and for an education, how can they dovetail with my caring for the same aspirations of my fellow students, such that they're advanced, but also I am improved as a human being by, in fact, that mutual caring that is connected to, but not simply equivalent to, caring just for myself.
So maybe many of you may know that the amendment that got added to the Constitution in 1992, the Congressional Pay Amendment, even though it was written by James Madison, it was ratified 202 years later. And part of the story of its ratification has very much to do with the college student at the University of Texas,
right,
who, after seeing all of the debates about deadlines and the Equal Rights Amendment, thought, well, if you have an amendment that was proposed and ratified by some states but never had a deadline, maybe age is no barrier to completing the amendment process, and started a letter-writing campaign. Now, I wouldn't say that his letter-writing campaign single-handedly made the 27th Amendment possible, but I would encourage people to think about things that you think not possible because of Article 5 for other reasons, and take action in a universe in which they become possible if they are morally desirable, because I think that shifts what's politically possible. And I think that so much of what hasn't happened with regard to constitutional change in the United States has been due to lack of imagination coming from the lack of civic virtues. So whether you agree with that student or even the 27th Amendment or the provenance of the 27th Amendment, I do think that changing one's mindset about what's possible is very important. And that involves not only studying constitutional history and constitutional law and what the Supreme Court is up to this term, but studying the constitutions of the states, including Illinois, that had a convention in a time that people remember, early 1970s, and also really looking at what's working and not working in other constitutional democracies around the world. Because I think shifting those baselines is the most important thing for thinking about the new constitution and the constitution that this country deserves.
Hello, I cannot see you, but I know you're there. My name is Michael Schneider. I'm Provost and Dean of the College, and it is my unfortunate responsibility to bring this extraordinary evening to a close. And I'd like to actually piggyback on the last comment that Professor Suk made about the failure of imagination, because one of my responsibilities was to send an email to the entire campus community that had the line, does the United States need a new constitution? Which is a comment or a question that in our popular media would almost never be heard or expressed. But at a place like Knox College, we recognize that this question opens a door. It raises other questions. It raises other ways of thinking about our constitutional order that demands that we engage and it demands that we attribute or bring our imagination to the question. And to this point, globally and historically, there has not been a failure of imagination around the issue of writing new constitutions. In 1867, after a brief and bloody civil war, the Japanese military government of the day collapsed, and no one lamented its departure. Instead, they set to work writing constitutions. Wealthy farmers in rural Japan wrote their own constitutions, and they did so having to invent the exact words that they needed to invest sovereignty in the people. They had to invent the words individual, people, freedom, and rights, but yet they persevered. In 1911, after over 2,000 years, the extraordinary Chinese imperial government collapsed, and no one tried to rebuild the empire. Instead, they set about to write constitutions, in this case mimicking the United States Constitution, not something that happens too much anymore. In 1922, Great Britain gave up its overlordship over the area that we now call Egypt, and Egyptian nationalists had to step in to begin to constitute a political order, in some case with the significant support of British Constitution writers. And they enumerated rights such as the right to public education, the right to privacy of property, of home, and the telephone. One of our most recent global constitutions, the Thai Constitution, is the 20th constitution that Thailand has had since the 1930s. Which proves the point that even today, the meanest autocrat insists that the state be constituted by a founding document of this sort, a document that guarantees enumerated rights and freedoms, even while in some cases sharply prescribing and trampling those rights in every way imaginable. But we should not look upon these complex histories, these many written constitutions, maybe failed constitutions in various ways, as with a source of despair, but rather, as Professor Suk just said, as proof that imagination is necessary, that the Constitution is a globally successful idea, and our engagement with it, our engagement in the possibilities of what the constitutional order should be, is exactly what is asked of all of us in this environment. So, to stop talking then, let me extend thanks to any number of people who made this extraordinary evening possible. First of all, the Office of Advancement at Knox College played many roles over a multi-year period to not only provide some funding for this idea, but to invite the idea of an ongoing series of campus debates on this campus. To the facility staff who set up where we're standing right now, dining services who provided water and other services, DELAC for the sound for this event, campus safety, and the City of Galesburg and the Galesburg Department of Public Safety that has also supported us tonight. Thanks to you who joined us in this discussion and many of the Constitution Day facilities that have festivities that have happened over the last few days. We invite you to please read on. The pocket constitutions, I believe, are available out there somewhere. Please, it's a little dark again from where you're sitting. The pocket constitutions are available, thanks to the Jack Miller Center for those. The National Constitution Center website is an extraordinary resource that has podcasts, educational videos, resources of all sorts, blog posts, and other things that can allow you to continue to explore the U.S. Constitution. We will make other resources, including the references to the Democracy Journal project that was discussed earlier, available on a website that has both then also the link to this particular event. Last few notes of thanks. First to the Jack Miller Center that provided financial support for this event. And frankly, to Professor Thomas Bell, who not only persevered in securing this function, but persevered over many years to actually bring an event like this to this campus. Congratulations and thank you, Thomas. And finally, let me thank most of all our esteemed guests who brought us these extraordinary ideas, this extraordinary opportunity for conversation. Please join me in thanking and welcoming Professor Julie Suk and Professor Jeff Tulis. Thank you. May you have a wonderful and safe evening. Thank you, everyone.